mede encha sonko ema daily trends etiefo enyina sabre daily trends da de bremu eno abia ena ene yesande eba omanga nsem yensem no yenko na yenkuti ensem a ewo ho
wo Accra High Court ene court no ekwa asetena ni nyina no chairman Wontumi the Ashanti Regional Chairman of the New Patriotic Party in case Egusua Ekoso Ewo Court that is talking about the Exim Bank case. Yes, for you to know, Chairman Wontumi or cases Sabre or Kahwasem, not only one case. Exim Bank in one of them, and then Summer Boy and so another, and then yes, other cases and so. Now, talking about the Exim Bank case, Sabre court no equasitina. The acquire any said the counsel for the defendant. Omo at the court say ebeya and court no. More time kakra. Say no. They've submitted omo the application koi. Say court no ma ho kwan na plea bargaining. Cause on electricity no maji. Edia two says Siciano, a quadro de abom, at least they now plea bargaining. Naturally said they should negotiate. Now be so intimate and cosi on the matter. Now, for the negotiations near the Kika Hono and Omo said Siciano looking at the time I will honor yard some bit me at the time one way or the other is shot. So court no almost had the coin said court no and more time extension kakra to the case and on near. Court no etimi etina se na court no etimi age ede atu court no etina se no court no etimi age ede atuma sisi reporter Sabre kayensa kire se court no I extend time no the court 27th of July omo ede ebetina asem ne so na kire se bibia so etimi akoso so the time them the space them no from now till 27th, and I wanna any the plea negotiations because that will be between the defendant, then the prosecution. It will be between the defense and then the Attorney General's department. So that will be how things will go. And on ebetwa negotiations are course. This was being made known by one of their counsel, the Chairman Wontumi, or not any the same way at the two year before no bra court no etina say a casa a year and on the same way at the to and I quote few words and then before say beko near quoting I said this is the Exim Bank case. We are yet to begin the substantive hearing, as this is the first matter in which the lawyers for the accused and the Attorney General's department have opted for plea bargaining. Today in court, we requested additional time to continue the negotiations. The court granted the request and adjourned proceedings to 27th July 2026. We hope to reach a settlement by then. Between the defense and the prosecution, no, or some Bibia Adana Pemeba na said court proceeding. Bibia no the council for Chairman Wontumi omo abrefie kaka na ewia de ohono yetimi ade atoaso.
Then the lawyer kai we Exim Bank case no yenya nhyase. This is the case edikan ababontin say lawyers for the accused person any Attorney General plea negotiations enya enwie pay enti ene back court no ya to court no anim say be here more time say betimi ayesa negotiations no na ewie a ne pomasi bre ne ya bedom court no so tiase ti wa agene court 27th of July hope say endru ho no na ya ye enhyehyɛ ya bia fa ho awie a na ya bedom court no na court no awe.
Yes, the Attorney General Dominic Ayini, should I move on, and the Deputy Attorney General Side. The two of them are prosecuting. We also know that Attorney General had already done the very bizarre thing by holding press conferences and almost certainly pronouncing the accused as guilty when that was not really part of his job. His job was to prosecute and allow the court to pronounce guilty. Tonight, the case has run to a certain level. It has gotten to an important threshold, an epoch. What is that epoch? When criminal trials begin, the prosecution will usually present their case. Presenting their case means that they will tell the court why they are prosecuting the individual, and then they will bring people, they call them witnesses. So prosecution witnesses. So when you go to court and you hear they say PW 16 is the 16th prosecution witness, P for prosecution, W for witness. So PW 1 up to wherever they choose, and the prosecution has the liberty to choose whatever they want. So the PWs have been interviewed. Interview means that they will call their names and then they will stand in the dock, and the attorney general or the one prosecuting, they call it examination in chief. They will ask them questions and then try to guide them to sort of give evidence and backing, give evidence and a lot of backing to the statements that the prosecution have made. When they have given this examination in chief, the lawyer of the one being prosecuted is allowed to ask them questions for clarification, to observe contradictions, and also to bring out certain information that will hopefully build up the case of the defense. When that has finished, and that is where they are in the Dubois case, that has finished now. When that has finished, then the defense counsel will also call its witnesses. And then when they come, the defense counsel will ask them questions, and he will be hoping that in asking them these questions, they will be dislodging the matters that have already been put before the court by the prosecution's witness. When defense counsel asks those questions, the prosecution is allowed also to cross-examine. In fact, there's a third level to it. If you ask your examination in chief and there's cross-examination, you can request the court that at the end of the cross-examination, you want to ask more questions, and that's called re-examination. So let's get that fact today. I'm going to show you what is happening in the Dubois case, and you will be completely blown away, viewers. Let's move on. Now, there are two things that we need to learn today before we move on. Yeah, it's about the standard of proof. So when you go to court and they say you have to prove beyond reasonable doubt, what is the proof that this? Where is the evidence that all that conversation is about? The proof of the matter, PROOF, proof of the matter. So there's something called the standard of proof. The standard of proof investigates what should be the level, how much should we prove, what is the burden. We should, if we say that Paul Adomotri visited Professor Jenano Opoku-Agyeman yesterday, assuming that is a crime, and we want to establish it, to what extent should we establish that? Should we be able to have a photograph of Paul Adomotri standing in Jenano Opoku-Agyeman's house? Should we also add trace his phone so that the GPS will show on his phone that the phone was actually in Jenano Opoku-Agyeman's house? That may not be a complete proof that he was there with the phone, but if we can go ahead to say that he made a call at 9 o'clock and he spoke on the phone, and at that time the GPS showed that the phone was in Professor Jenano Opoku-Agyeman's house, then we are getting somewhere. So the standard of proof is, to what extent should we prove that this happened or that didn't happen? So standard of proof. This is from Black's Law Dictionary, so you can always check. It's a law dictionary called Black's Law Dictionary. You can just Google it and find out. The standard of proof is the level of certainty and the amount of evidence required to prove a claim in court. It dictates how convincing the evidence must be for a judge or jury to decide in favor of one party over the other. And this is the important part. The standard of proof dictates how convincing the evidence must be for a judge or jury to decide in favor of one party or the other. So the standard of proof is by and large legislated upon. So what is the standard of proof? And what the courts and the Anglo-American common law have done is that they have just separated the standard of proof into one standard of proof for civil cases and another standard of proof for criminal cases. So let's get there and find out where we are. Okay, so this is the standard of proof for civil cases. On what is a civil case, by the way? A civil case is the one that doesn't involve the government and the attorney general. It doesn't involve the police. The attorney general can also sue in a civil action, but normally when we see a civil case, it's between one Ghanaian and another. It could be one foreigner who has right to practice business in Ghana and he's angry with something he's suing. So two civilians, two individuals, no one is calling police to arrest anyone. Criminal cases are different. Criminal cases are prosecution by the state against an individual, and the state is involved because one individual has reported to the state that another Ghanaian or some foreigner who has to be in Ghana has done something against me, that's something that he has done against me, you will find it in the Criminal Offences Act. There is a document called the Criminal Offences Act where all prohibitions have been listed. So if you go to the Criminal Offences Act, which is Act 29 of 1960, but as amended, you will find one, they say stealing, they define it. This, they define it, defrauding by false pretenses. So if the action that has happened can be found in the Criminal Offences Act, you are free to go and report to the police that this person has stolen my money. The police will prosecute. That's criminal prosecution.